Welcome to week 4 of the course. I would like to review briefly last week's discussion of inadmissibility. Recall that inadmissibility means a disqualification from applying for a visa and from entering the United States. I referred to it last week as a gateway because it is the preliminary step in determining if a person is eligible for a green card. This week, we turn to the legal immigration system, and in particular, we focus on the various pathways to obtaining legal permanent residence, the green card. If you get past the inadmissibility gate, you'll have to qualify in a particular category in order to get a visa. We also looked briefly last week at the process for determining whether a person is admissible. The background checks are extensive and take a lot of time. Current proposals for legalizing the status of undocumented aliens who are already living in the U.S. call for 4 separate background checks on the pathway to citizenship. In this lecture, I provide an overview of pathways to a green card or permanent residence in the U.S. with the possibility of becoming a U.S. citizen. We will discuss each category in more detail in future lectures. One goal for the week is to understand why many politicians and legal scholars have, for at least a decade, referred to the immigration system as broken. Both political parties agree on this. I'll start with a general survey of a very complicated system. Before we discuss pathways to permanent residency and possible U.S. citizenship, keep in mind that we are not at this point talking about temporary visas. With a temporary visa, for example, a tourist or a student visa, you cannot be employed in the U.S. and you must leave at the expiration of that time period. Tourist visas are typically good for 60 days in the visa waiver program and for 6 months to 1 year otherwise. The debate on the broken immigration system, however, has to do with permanent residency. Who can come here permanently? Let's begin with an overview of legal immigration. There are 4 categories of people who can apply for green cards. In some of the categories, you are immediately eligible for a green card. In others, you must wait until one is available. So let's take a look at those. Family-based immigration is one of the most important categories. A U.S. citizen or LPR, and recall that stands for Lawful Permanent Resident, can sponsor his or her close family members for permanent residence. The second category, also a very important category, employment-based immigration. A U.S. employer can sponsor a foreign national employee for permanent residence. Third, refugee or political asylum. We'll say more about this in future lectures, but every year many people seek asylum in the United States or try to get a green card as refugees. The two are often thought of as the same category, but there are some technical differences. And finally, the 4th pathway to a green card is the diversity program. Many people are surprised to learn about this program. 50,000 visas per year are set aside, and they are set aside for underrepresented countries, countries that in recent years have not sent many immigrants to the United States. The purpose of this program is to ensure a varied ethnic mix among people who immigrate to the U.S., although applicants must also meet certain educational requirements. The method used for choosing people who can apply for these green cards is a random selection by computer, so the program is popularly known as the Green Card Lottery. Now let's look at the problems associated with those 4 categories that have led some people to conclude that the immigration system is broken. First of all, there are numeric limitations, and we'll see the implications of those numeric limitations in just a moment. Family-based immigration is limited by statute to 480,000 persons per year. This is with the exception of immediate relatives of U.S. citizens who are not counted completely against that number. Employment-based immigration is limited by statute to 140,000 per year. These are worldwide numbers. Each country also has limits based on a rough 7% of the total that are available, and each visa category also has limits. So the question is, what happens when there are more people seeking admission than available admission slots? And this is a very important question because this happens constantly and has happened for years, that there are more applications than there are available visas. Per-country limits exist to ensure that high demand in one country does not use up all of the available worldwide visas. Applicants from a single country that has not used up its 7% green card allotment can still be prevented from getting green cards if the worldwide quota has been exhausted. There are currently waiting periods in many preference categories. Let's talk about how the numerical limits affect the wait for a green card. If a family member or employer petitions for you in a preference category, we're going to talk about preference categories in lectures later this week. The wait could be several years long from that point of petition, and that's because the demand for green cards is, in most categories, far greater than the supply. So thousands of people who applied in previous years are still waiting for their visas. So the State Department has devised a system where the people who have been waiting longest have the first right to a visa. And this is where we want to introduce you to the Visa Bulletin. This is a monthly publication of the U.S. State Department. It's complicated to understand at first, but I want to walk you through this briefly so that you can understand the extent of the problem with waiting periods. So this is for the family-sponsored categories. And let's assume that in May of 2013, and this is the May 2013 Visa Bulletin, a family member has petitioned for you to come to the United States with a green card. And let's say that you fall into one of these family-sponsored categories. And just for an example now, let's look at F2B. And we'll talk about tomorrow what category that is. But let's assume you fall into that category. Now, when you look at the dates for, it says all chargeability areas except those listed. That means every country except the 4 that are listed: China, India, Mexico, the Philippines. Look at how long your wait is if you fall into the F2B. It says 15 May 05, so 2005. What that means is, when this date is published, anyone who had a visa application filed prior to or up to May 15th of 2005 are now being processed. So that's an 8-year wait period. And using this table, that's a rough estimate of how long you would need to wait if you are just now filing a petition. Again, it's because it is a first come, first served in a sense. If people are in line and have been in line for a long time, they get priority for the visas. Now, let me explain why 4 countries are listed separately here. The demand is much higher in China, India, Mexico, and the Philippines than in any other country. And as you might expect, the wait is longer. So if we look at, for example, the F3 category, which, as we will learn, is married children of U.S. citizens. If we look at the F3 category from, for example, India, the wait is about 11 years from application for the green card to the granting of the green card. If you look at Mexico, they are just now processing visa applications from 1993. That's a 20-year wait. And from the Philippines as well, about a 21-year wait. So you can see that the backlogs are substantial in some of these categories. And even in the F1 category, the first priority for family-based reunification visas, you'll see that in India the wait is approximately 7 years. In Mexico, again, it's 1993. So about 20-year wait, and then the Philippines, 1999. So that is a brief overview of how the Visa Bulletin works, so that you can get an idea of what the backlogs look like and how one would go about predicting, if you applied today, how long it would take to get your green card. Now, we also said that employment visas are limited by number to 140,000 per year, and similarly, the Visa Bulletin will list employment availability, and this is the chart from May 2013. C means current, so that visas are currently being processed, and you can see that the first priority employment-based is all categories are current for all countries. We will also later in the week come back to employment-based and look closely at these categories. But there are also some significant delays in employment-based categories for the third preference and other workers, and you can see some of the dates there, particularly with India, also with Mexico and the Philippines. But in India, third preference employees are waiting 10 years approximately. The waiting periods from people from the Philippines tend to be longer than from other countries because there are so many applicants and a limit on how many can come from any one country. Most people will wait less time if they come from countries in which demand is not quite as high. For example, if you were from Brazil and were the spouse of a lawful permanent resident, you would look at the category for row 2A with the last slide, and it would be the first box, all chargeability areas except those listed. The corresponding current priority date there is March 1, 2011, meaning you could expect a wait of about 2 years if you applied in May 2013, which is the date for this Visa Bulletin. This backlog is part of the reason the U.S. immigration system is considered to be broken. Current reform proposals to legalize the status of undocumented persons already living in the United States specify that they must, quote, get in line behind those who have been waiting for legal permanent residency. It's thought to be a fairness issue. Why should someone who has disregarded immigration laws go to the front of the line or get a green card more quickly than some of these persons who've been waiting for a decade? It is not clear how this would work unless those backlogs are eliminated entirely. So I want to conclude with something of a disclaimer for what we will cover this week. The immigration system is extremely complicated. This course provides a general summary only. You will need to seek expert advice for specific immigration problems. I note this so that you will understand what I'm presenting is a simplified overview so that you can understand the main features of the current system. Avoid scams. There are lots of scams out there, ranging from scams overseas with the diversity lottery to scams for immigrants here, persons holding themselves out as immigration experts, making promises for what they can do and taking money. So be very careful. I would like to recommend a book that is, I think, an excellent guide. And for those of you who would like to learn more, have more detail about what I am speaking about, this one is very helpful. It's by Bray, U.S. Immigration Made Easy, and it's a Nolo Press book. And here is the website if you would like to take a look at it. I've also provided in the reading for this week additional detail to supplement these lectures.
The preceding program is copyrighted by Emory University.